Good morning, good afternoon. On behalf of IBRAC, I would like first to thank our speakers, Aldo, Isabelle, Lucas, and Steve, so for joining us today and for bringing us some thoughts and discussions about this subject, US and EU sanctions against Russia. The webinar will be in English. It will take 1 hour and 30 minutes and will be divided in 2 blocks. And also I would like to thank Mauro and Vito for being our moderators today. And so I will pass the word to them so they can introduce the subject and the speakers. Thank you.
Thank you, Carol. Good morning to everyone and good afternoon to our colleagues in Europe. Today we will have a webinar on a very hot topic at the moment about the US and EU sanctions against Russia. But before that, I would like to give the floor or the camera to my colleague and co-moderator, Vitor Lopes, to briefly give us some context on the export controls and sanctions scenario in Brazil. So, Vitor.
Thank you, Mauro. Good morning or good afternoon to everyone. So, in Brazil, there is an interpretation that prevails that the Brazilian Federal Constitution forbids the adoption of unilateral sanctions, right? So Brazil has not applied any unilateral sanction, but Brazil is a member of the United Nations, and as such, it complies with the sanctions approved by the United Nations Security Council. And also, Brazil is a member of a series of international treaties and conventions. For example, the Treaty on the Non-Proliferation of Nuclear Weapons, the Chemical Weapons Convention, the Biological Weapons Convention, and the Missile Technology Control Regime. And the goods and services covered by such treaties and conventions are classified by the Brazilian legislation as sensitive goods or services, and their exports, therefore, are subject to government control. And this control is implemented by CIBIS, which is the Interministerial Commission for Export Control of Sensitive Goods, which is coordinated by the Ministry of Science and Technology. And CIBIS has approved several lists of goods, services, and software that are subject to such control, right, which is implemented through the SysComex. So this is briefly the Brazilian regulation on control of exports. Mauro, back to you.
Now I will introduce our US colleagues and first speakers, Jason and Lucas. So Jason Waite is a partner in international trade practice leader at Alston and Bird in Washington, D.C. He concentrates his practice on regulatory aspects of international trade and investment. He counsels clients on export controls, economic sanctions, customs and free trade agreements, and foreign investment regulations. He's a frequent speaker at seminars and conferences on international trade topics and has been recognized in Chambers US as an America's leading lawyers for business and in Chambers Global. I will also introduce Lucas, since after this introduction, they will both speak on the subject. So Lucas Queiroz Pires is a special legal consultant at Alston and Bird in Washington, D.C. His practice focuses on a variety of international trade, compliance issues, including customs, trade remedies, tariffs, trade policies, sanctions, and export controls. He's a dual qualified lawyer in Brazil and the US. Lucas previously practiced at the Maresti law firm in São Paulo, focusing on international trade and government relations. And he was also interned at the Legal Affairs Division of WTO. So now I will pass the floor to Jason. And perhaps, Jason, you could start by explaining to us why export control and sanctions is such a powerful tool to the US government, especially when we compare to the scenario just described by Victor Lopes in Brazil, where we have a very timid approach to it.
Sure. So US sanctions are not new. The topic has gotten a lot of currency recently because of what I would characterize as an unprecedented wave of new sanctions imposed in response to the Russian invasion. And but US sanctions have long been around and have been used by the United States to further foreign policy and national security interests. The reason that they have such an impact in the global business community is because the U.S. dollar is the reserve is such a commonly used currency in trade, and that gives the U.S. a jurisdictional basis to restrict transactions. You know, I think when you go back to sort of the root of sanctions, it is rooted in the continuing predominance of the U.S. dollar and the sort of influence or the sway, the power that the U.S. can on businesses. We're also a pretty big economy, and so a lot of transactions and a lot of businesses touch our economy. They touch our financial system, and this gives U.S. sanctions a sort of a broad reach, which just kind of fuels the U.S. ability to use them as a tool. That's pretty much why U.S. sanctions have such a bite, and why, it's funny, we're getting probably as many questions or more from non-U.S. companies than we are from U.S. companies, right? Non-U.S. companies, Europeans, Asians, African financial institutions, all over the world, companies want to know, how do U.S. sanctions affect them? And I think, and sometimes the answer is they don't. You're lucky, but a lot of times it is that they could affect you because you have these connections to the United States, or your transactions in dollars, and so companies want to track that. I'm gonna turn it over to Lucas, talk a little bit about how this might apply in Brazil.
Sure. Thank you, Jason. So first, thank you, Carol and Mauro. Also, apologies for my voice, but fortunately, I don't plan to speak a lot. I'm surrounded by experts like Jason, Isabelle, and Aldo. But yeah, to talk about the impact to Brazil and why are U.S. sanctions relevant to Brazil and other origins. It's interesting because when I practiced in Brazil, as Victor and Mauro introduced, the U.S. sanctions was not a big thing, right? Like, it's not, trade lawyers are not, they do not practice, sanctions is not a core of its practice. But here, because of the reasons that Jason just explained, it is a thing because it affects not only all U.S. parties, but also it has the potential to affect foreign parties. And now we are seeing this trend of U.S. sanctions increasingly applying directly or indirectly to foreign persons. And we see financial institutions, and we also see service providers using the de-risking policy. So it's not uncommon for a bank to not proceed with a transaction when it sees that it involves a country that is subject to sanctions, like now Russia, right? So as Jason said, it could be the case that the party in Russia is not sanctioned, but because the foreign institutions and service providers want to be more risk averse, they adopt this de-risking policy and they end up not proceeding with the transaction. And I think this explains why foreign persons like Brazilian companies can be affected, because Brazilians companies, they...
Should we have our PowerPoint up?
Sure, I can share the PowerPoint. There you go.
I think you're on slide 2.
Can you see the screen? Okay, cool, thank you. There you go. So we are on slide 2. So in terms of the authority, right? So OFAC is agency under the US Treasury, the Office of Foreign Assets Control. OFAC has the authority to penalize any person, including foreign persons not in the US. And this, the statute, one of the most important statutes that justifies OFAC's authority is the IEPA, the International Emergency Economic Powers Act. And we can see the language of IEPA Enhancement Act of 2007, that it makes it unlawful for a person to attempt to violate, to conspire to violate, or to cause a violation of OFAC sanctions. So you see that the language of the statute provides some discretion, right, for the US agency to penalize a US person or any person if that person violates a US sanction. And we also see in the language of the statute the facts that give rise to violation. So it can be like an export, cause an export, or other violation, an attempt to cause an export, act or with knowledge of a violation, conspiracy. So these languages, they provide the US authority a pretty big power when it comes to sanctions. And that's why financial institutions are very concerned, and they're very on top of it, and they frequently check this US sanctions list, because the transactions in US dollars, they have this international element, right? They have this jurisdiction element from the United States. So it's not uncommon for financial institutions to be very much on top of the US sanctions programs, because they do not want to be this person that attempts to facilitate or to process a transaction of a sanctioned party. And this, and also the SWIFT payments, right? The banks, they use the SWIFT data to determine whether a party should be blocked or rejected. So when it comes to US sanctions programs. So this illustrates why these financial institutions need to be on top of the sanctions programs, because they can easily be considered this middleman that will potentially facilitate a US transaction concerning a sanctioned party. So yes, go ahead.
So this next slide is about primary sanctions and secondary sanctions, and to sort of put a finer point on what Lucas is explaining, because in my experience, when I'm advising non-US based clients, one of the most common points of confusion is the jurisdictional reach of the sanctions, and often there's confusion between primary sanctions and secondary sanctions. Primary sanctions are what Lucas was just talking about. Non-US persons can get caught up and can violate primary sanctions where there's a US person involved, like where they use a US bank or where their counterparty is a US person. A non-US person can potentially be drawn into a violation of US sanctions because a US person is involved. But that's different from secondary sanctions. So, so primary sanctions, there is extraterritorial reach, but it requires some US connection, right? A foreign person can be caught by virtue of involving a US bank or involving a US counterpart. But if they are caught, they can be directly the subject of enforcement under the primary sanctions regime, enforcement that includes civil penalties, potentially even criminal cases. If you followed, over the years, there have been many big US cases against big foreign banks like SocGen, like Commerzbank. The reason that those banks get caught is because they involved a US financial institution in their deals. That's primary sanctions. Secondary sanctions are very different. And again, I find that non-US parties sometimes mix these up. Secondary sanctions are where there are no US persons involved, where the foreign actor remains outside the US jurisdiction. Maybe they've been very careful. Maybe they haven't included, maybe they've made sure they're not using US dollars. Maybe they've made sure that the insurance company they're using is not a US insurer, and the transportation provider for the goods is not a US person. Maybe they've been very careful and nobody involved is a US person. Well, you would think that would be good enough. And it usually is. But the concept of secondary sanctions is this additional threat that in certain circumstances for certain types of what I'll call sanctionable activity, but it's really activity that's particularly offensive to US national security or foreign policy concerns, then that foreign person could itself become the subject of a sanction or be the subject of certain other privileges, denial of government contracting rights and certain, Ex-Im Bank rights and things like this. But the big stick is if you're a foreign person, we may not be able to penalize you in an ordinary enforcement action using our normal rules and regulations, but we can just decide we're going to sanction you. Okay. Now, in my experience, and what we've seen over the years, this really dates back, secondary sanctions kind of emerged as a major US tool in the pre-JCPOA days, right? That was the big controversy. We had a unilateral sanction. The US was trying to, it was largely unilateral sanction, and the US was trying to bring the global community on board. And one of the ways they did that is through this big stick or this threat of secondary sanctions. And so because companies were concerned about that, in many companies were pulled out of certain dealings with Iran. Companies that were not directly subject to US jurisdiction, they didn't want to take the chance that they could be put on the US radar and be the target of sanctions. But secondary sanctions are rarely applied. This is not a common event. It is an inherently political determination, and it's usually been reserved for parties that also happen to be based in countries that are not US allies or friends, right? So I think, we always are very careful to advise our foreign clients, let's make sure that there's not a primary sanctions issue, because that's a much more realistic and everyday compliance problem. And if there's not, we can then talk about sort of the types of factors that might make this a meaningful secondary sanctions risk. But again, secondary sanctions requires an affirmative act. The US government needs to look at a matter and decide this activity is concerning enough that we're going to take a step. You can imagine that if they took that step against commercial actors in allied countries, that creates diplomatic challenges and things like this. So it's not very common. The threat of it is sometimes still keeps people awake at night in countries outside the United States. But it's, we have a very pragmatic view of secondary sanctions. You really need to be doing something that's going to get attention and really be contrary to US policy to be put on that list, if you will, and on the radar for secondary sanctions. Do you want to go do you want to do 6, or do you want me to?
Sure, I can do that. So now talking about the general framework of sanctions, right? So sanctions here in the United States, they can be categorized under comprehensive and list or sectoral, right? So generally, they all restrict dealings with certain countries or person, and they apply to goods and service and transactions. And we have the comprehensive are like those trade embargoes, like we used to have with Cuba, for example, complete ban, no transaction at all. And those are rare. Those are not too common anymore. Now, what we do have are more sectoral or targeted. And an example of a list-based sanctions or sanctions where we can see the list of parties that are being sanctioned and is very important. And foreign parties usually are paying close attention to it is the SDN, specially designated nationals, or the blocked list or the US sanctions list. So this is a list that is publicly available. Everyone can check. We can just type the name of the company or the person, and then we can see if it is covered there or not. And this is a good place to start when parties want to make sure that they are not, making any transaction with a sanctioned party. As Jason will explain later, this SDN list is not exhaustive. Companies need to do some diligence, because if they are owned or indirectly owned by a party that is an SDN, they are also sanctioned by operation of law. So it's not exhaustive, but it is a good place to start, and Jason will touch on that later on. But then just moving forward on the general framework, the sectoral or targeted sanctions, they prohibit specific types of transactions. So certain debt and equity transaction with certain persons, those are more common in the US sanctions environment. And we see in the case of Russia, for example, as Jason will explain, that this will be the case, more sectoral and targeted sanctions as opposed to complete full embargoes. And each sanctions program is different. If we go into like OFAC's website, we see programs for Russia, Venezuela, Iran. So this is just to explain how the sanctions programs work. Do you want to go over the legal?
Yeah, so I mean, it's great for lawyers. Every program's different. There's this broad executive authority. The legislative branch has given the executive branch in the United States this fairly broad authority to impose sanctions in the event of when there's an unusual and extraordinary threat to the national security. And so then the president can issue executive orders, and then often those orders will authorize the Secretary of Treasury and or the Secretary of State to then take actions, right? So there is this cascading effect. There is this broad legal authority. IEEPA is the primary authority, although we can't forget our old friend, the Trading with the Enemy Act. Our US sanctions are mostly based on IEEPA, but the Cuba program is still based on the Trading with the Enemy Act. OFAC is the agency that administers these. They are the ones that when the president says, you are here, we're hereby we're authorizing you to target entities that are, violating human rights in Belarus, or that are, supporting malicious cyber activities. Then the Treasury Department goes out and identifies those parties to sanction, and then issues, targets them. It's not exactly true that sectoral sanctions have overtaken our traditional sanctions regime, but it has been because we still have plenty of SDNs, we still have significant comprehensive embargoes, right? But it's true that sectoral sanctions, this idea of developing these kind of ostensibly more surgical sanctions that prohibit certain types of transactions, we've seen it. That's evolved. That basically was created around the invasion of Crimea. The Obama administration kind of created these more targeted sanctions around certain types of activities. And we're seeing that. Of course, we're going to hear from our European colleagues. I think they're going to have some similar tales to tell about that. SDNs, if somebody's on the SDN list, their property and their interests in property are blocked, and U.S. persons can't do any business with them. That means, what does that exactly mean? Well, it's easy when you think about it in terms of a bank account. If Mr. Putin had a bank account at the Bank of America in New York City, when he got designated on the SDN list, the Bank of America would have blocked that account, which means, they make it's really an internal transaction where they block it, where they don't allow things to go in or out of it. And then they report it to OFAC and it remains blocked. that same concept applies to all kinds of property, although it can get a little more fuzzy as to how exactly you block, an interest in an insurance policy or an interest in real estate. But it is blocked, and it can't be, and nobody can act on it. Nobody can buy it, sell it, support it, service it. It's blocked. It's a little bit different from I think it's a little bit different from the European approach, and I look forward to hearing on sort of some of the slight distinctions between blocking and asset seizures and that we might see in Europe. Lucas was mentioning the 50% rule, and that is also it's a big topic, right? Especially with Russia, because we have these targeted elites, and these elites have holdings around the world, and where these elites own 50 under the U.S. rule, where they own 50% or more of a company, directly or indirectly, then that company is considered sanctioned. And so, doing business with this opens up a whole range of sort of compliance questions for companies in the global community. To how much due diligence do I do? What do I need to research in terms of ownership? And of course, the answer is it's a risk-based approach. We would recommend a risk-based approach. The government would recommend a risk-based approach. And then we need to decide, depending on the nature of your transaction, how much deeper we need to dig into the ownership to determine, and of course it gets pretty complicated, again, especially with Russia, because, it was remarkable. I found it really remarkable, the number of Russian wives that found themselves owning massive percentages of companies around the world in the days before their husbands were sanctioned. It must have been an anniversary or something. But we do see a lot of moving of assets like that, right? So, and you'll see companies scrambling to issue press releases and make statements about whether their ownership remains sanctioned. And also, we're going to hear from our European colleagues on this, because there's a slightly different rule in Europe. Never before have we in the United States have often struggled with some of the difficulties of OFAC. It's not always the friendliest or most transparent agency, but OFAC has a 50% rule, and it's pretty straightforward, and it's pretty easy to meet or to address. And I think in Europe and the UK, we've seen a slightly different rule, and I'm hoping we might hear a little bit about that. There's a little more of a subjective analysis in Europe there in terms of determining whether a party is sanctioned just by virtue of its owner being sanctioned. Next. We'll go fast on this one. I mean, yeah, you can get in trouble for this stuff. If you violate U.S. sanctions, there are pretty steep penalties, $330 or twice the amount of the violation. There are enforcement guidelines on the civil penalty side that OFAC administers, and that give us a little more insight into sort of how to evaluate exposure to civil penalties. And the as you can see on the slide, the basis of sort of a base penalty calculation is based on the transaction amount in many cases. I should say at least in cases that are not egregious. The penalty base will be based on sort of roughly on the transaction amount, and then it can be reduced based on a voluntary disclosure and other mitigating factors.
Yeah, and these are adjusted quarterly based on inflation to this. Annually, sorry. Yeah.
So let's talk about Russia. So
yes, Russia.
The Russia sanctions, obviously they've been expanding. It's been for the first few weeks we had multiple actions a week. It's kind of leveled out. These sanctions fall into a few categories. You've got the elites. You've got the government officials and elites being targeted. You've got major Russian financial institutions being sanctioned. Financial institutions have been sanctioned. Some of them have been fully blocked. Others of them have been subject to more targeted sanctions. Some of them that were originally the subject of more targeted sanctions, like Sberbank, for example, have been moved into the fully blocked category by the United States. So it's an evolving situation, and it's difficult to keep track of. It's also challenging because I'll say this, more so than any other sanctions program, it really is. I mean, these are unilateral sanctions, but it's a multilateral effort, right? You have a unilateral U.S. sanctions program, but it is part of a multilateral effort with Europe and the UK, also taking similar actions. And so, anytime you're looking at the U.S. sanctions, or any advising somebody, you're having to kind of consider all three regimes or multiple regimes. The U.S. Blocked trade and investment in dealings with Donetsk and Luhansk. I've yet to have a client that has been very upset about that. I don't know. I've never been to Donetsk or Luhansk, but that has not been one that's been animating a lot of questions. There was the central bank, the National Wealth Fund, the Ministry of Finance. They were cut off from financing. Their transactions with U.S. Financial institutions were blocked. We've also had a number of other actions, including prohibitions on new investment, prohibitions on U.S. imports, U.S. imports of oil, gas, coal, fish, alcohol. We've had U.S. export prohibitions that I think, including on luxury goods, alcohol, tobacco, jewelry. I think there's a very similar prohibition in Europe. We've had prohibitions on banknotes. I think the big one that is kind of sitting there now that we're waiting for more guidance on is the prohibition on investment, U.S. person investment in Russia. I was on a call with OFAC a week and a half ago or so, and there were lawyers sort of complaining that we need more guidance on this, and OFAC says they're going to come out with more. It's really a question of how broadly do they interpret the definition of prohibited investment. Some people have been worried that it could even extend to, what do you do if you have what if you have a subsidiary in Russia and you need to send them you need to send them money, you need to, they need equipment, you need to issue a guarantee for that equipment to help them finance that equipment, something like that. People are concerned that the broad investment prohibition could somehow catch that type of activity, and we're kind of watching that pretty closely. There have been a lot of this is still remains list-based sanctions. People ask me, well, can we still do this business in Russia? I say we do not have a comprehensive embargo on Russia. We have a number of prohibited activities and a number of listed entities and parties, and this is really what we have. So it's all about what the transaction involves, who's involved in it, to analyze whether it's prohibited under U.S. sanctions. I'll make a quick mention of, this is really primarily focused on sanctions, and export controls is really a different set of regulations and a different set of rules, but there was a pretty substantial U.S. revamp of our export controls that has the effect of restricting a lot more goods going to Russia, it covers goods that didn't previously require a license. Now they do. It also extends. There were a number of parties that were added to some export control lists, and there was also a new rule that would capture more foreign-made products if those foreign-made products incorporate U.S. content or technology and are headed to Russia. And interestingly, there was an unprecedented carve-out from that rule for a list of European allies and partners, and I think it reflects. It really does reflect the enormous cooperation that I think has been ongoing between the governments. And the Europeans, I think, as part of that cooperation, came out and added some export controls to things that they didn't normally control, as to sort of more closely align with the United States. So I can't say these are fully aligned regimes, but they are definitely sort of rowing in the same direction. And it's pretty remarkable to me, because we've had more than one situation where, of all the hurdles that a company had to get over to do a particular deal or to support a particular project, it was European export controls that sort of held them up, which is not something we've traditionally seen. General licenses. So how are we doing on time? I think we're on track, right?
2 minutes.
Perfect. So general licenses. So in the U.S., what happens is OFAC, all these sanctions that we've been talking about, they restrict transactions or they prohibit transactions. But anything can be licensed. So the technical answer is your transaction is prohibited unless there's a license. And you can get a specific license. You can go to OFAC and say, we have this problem. We need a license to do this transaction with a sanctioned person or to make this investment or what have you. But there are also general licenses. And are they up to 27 now, or do we have more than 27? I mean, OFAC has a long history of, they will proliferate general licenses. And you have to read the very precise terms of these general licenses to see exactly what they cover. But there are some that are useful. There are licenses related to agriculture and medicine and medical devices. And for example, we have some clients in the healthcare sector that have ongoing distribution and clinical testing and things like this in Russia. And we believe that license authorizes that, their activities, notwithstanding the involvement of some sanctioned banks. There are also licenses for humanitarian and NGO activities. There are licenses related to telecom and communications. These are kind of traditional licenses that tend to exist in all sanctions programs. Humanitarian, NGOs, medicine, agriculture, communications. We want to, if Twitter is allowed to send its feeds, its apps to Russia because we want the Russian people to be able to communicate. We want there to be access to other forms of communication. There are also a number of what I call wind down licenses that basically authorize transactions with a designated person to wind down your dealings with that person up until a date certain in the future, right? So wind down licenses have been issued with respect to Sberbank, for example, and several others. So that's the kind of thing where you have a business already ongoing and the sanction came down and you want to know whether you can still do it. There are some wind down licenses. But if you don't have a general license that applies to you, you can ask for one. Oh, another big general license that people rely upon is the licenses related to dealings with the central bank and the Ministry of Finance. So, it turns out that if you pay your taxes, if you're in Russia, you're paying your taxes, you're dealing with the Ministry of Finance and the Russian central bank. That's now been authorized. That's not illegal for you to do if you're a US person. So there are some useful general licenses and, there may be more. We are in the process of seeking some specific licenses, and we know that some have been issued, and we know that OFAC is they have said that they're surging resources into managing license applications on the Russia program. So that's coming. I'm going to turn it over because I can't wait to hear what Isabelle and Aldo have to say and sort of to hear how much of this sounds like an echo of what I just said and sort of maybe point out some of the things where there's some differences. And I'm looking forward to that. So I'm going to.
Thank you, Jason and Lucas. So I will just make a quick introduction of Isabelle and Aldo. Isabelle Van Damme is a partner at Van Bael and Bellis. She specializes in EU law and international trade law. She represents governments and individuals before various international courts and tribunals, including the WTO dispute settlement bodies, the Court of Justice of the European Union, and FTA tribunals. She assists clients with matters involving compliance with export control legislation and UN, EU, and national sanctions. She previously worked at the Court of Justice of the European Union, where she worked on several high-profile sanctions cases. And Aldo Scalini is a counsel at Van Bael and Bellis. He specializes in EU law with a particular focus on trade law. He has extensive experience in assisting public bodies and individuals affected by EU sanctions. He also advises international companies on compliance with trade and economic sanctions and export control laws. So please, Isabelle and Aldo.
Thank you very much. And on behalf of Van and Bellis, Aldo and I want to thank IBRAC for this kind invitation to explain to you the main features of the EU sanctions and also then answer all your questions that you might have regarding these sanctions. So the first question is, what are the EU sanctions? Aldo, next slide, please. I'll just wait for Aldo to change the slides.
This happens sometimes when you are on presentation mode, that the person projecting the slides move to the next slide, but we just see frozen the first slide. So
okay.
Aldo, if you could take out of the presentation mode, I think will be better.
Okay, let me try. Sorry for that.
Don't worry.
Let me. Now, I will share it once again. Now you can see.
We are on slide number 3. Try to move to the next one. Let's see if it works. Yes, it's working.
It works. You can stay on slide 3, Aldo.
Okay,
thank
great.
you.
Yeah.
Thank you. Apologies for that technological problem. So in essence, the question is, why do we have these sanctions? And our US colleagues have already addressed this question from the US perspective. In the European Union, sanctions are adopted not that much because of the importance of the euro as a currency, but really because the EU sees this as a foreign policy tool. It sees sanctions as a tool to put pressure on individuals, entities, countries to bring about a change in their policy or to end certain illegal conduct or to respond to certain emergent or current crises. And so the EU sanctions partly implement UN Security Council resolutions, similar to what was explained in respect of Brazil, but then the EU asserts broad powers to adopt its own sanctions, so where there is no UN Security Council resolution supporting those sanctions. As Aldo will further explain in the second part of our presentation, although the sanctions are adopted at EU level, there is an important role for the member states also in administering these sanctions. And basically, you need to go to the member states to ask for a license or authorization. And it's also the member states that set the penalties for not complying with these sanctions. Overall, the targets of these sanctions can be governments, they can be entities, companies, groups, organizations, and also individuals. Next slide, please. So the EU sanctions map is quite wide. Here you see all the countries in respect of which sanctions are applied. Similar to what our US colleagues explained, not all sanctions are the same in respect of all of these countries. So the measures can be quite different. The widest sanctions are probably those that currently apply to Russia. And what we are seeing with a lot of clients, including clients outside the European Union, is that as a result of the Russian sanctions, they are more closely looking at their supply chains to see, are there touch points with the European Union? And they're discovering that actually some of their supply chains might also have connections with the EU and certain other countries that are covered by EU sanctions. So for a lot of companies, the Russian sanctions have caused them to have a critical look at their due diligence program with respect to sanctions and their supply chains. And they are widening some of the questions to cover not only the Russia sanctions, but possibly also certain other sanctions that apply under EU law. Next slide, please. So to understand the sanctions that the European Union applies against Russia, there are basically 3 groups of sanctions. The first are the so-called targeted sanctions, and this widely corresponds with the notion of the SDN list that our US colleagues explained. In essence, this is about the European Union listing individuals or entities, and if you are included in the list of the European Union, this immediately brings with it certain consequences. such as also an assets freeze, but also a transaction ban. Second, there are these trade sanctions. And the trade sanctions against Russia is a broad group of sanctions. They relate to certain dual-use export control measures, but also cover export bans and import bans with respect to a wide variety of products and related services. As we'll explain, there is no standalone prohibition on supplying or receiving a service. That doesn't apply under the current sanctions. Any restrictions on services must be linked to a good that can't be imported or exported. And there are also certain transport restrictions and also procurement exclusions that apply. And third of all, we have this very wide category of financial sanctions, which includes, for example, the SWIFT ban, but also various restrictions in respect of investments, the ban on supply of certain financial services, or the prohibition to deal in financial instruments and extend credit. Next slide, please. Now, one of the main questions that you might have as a Brazilian company is, well, are we affected by these sanctions? And similar to what our US colleagues explained, it is important to focus on what triggers the application of the sanctions legislation as such. I want to caution that this doesn't mean that any of your conduct with an EU party and a Russian party is necessarily prohibited. It's just a question of, do you fall within the scope of application of EU sanctions? And a critical position to underscore is that the EU sanctions do not apply extraterritorially. So there must always be a link with EU nationality or EU territory. But that doesn't mean that the EU sanctions have a narrow scope of application. Rather, the contrary applies. So there are basically 5 criteria to check to see if you fall under the EU sanctions. The first criterion is that the sanctions apply within the EU territory. That's the clear territorial link. It also second applies to nationals of EU member states. So if you are a Brazilian company and you are employing EU nationals in Brazil, then those EU nationals must comply with the EU sanctions, even if they are outside the European Union. Third, the sanctions apply to entities incorporated or constituted under EU member state law, so basically EU companies. This also means that if you have a subsidiary in the European Union incorporated under, for example, French law, that company must comply with the sanctions. Fourth, the sanctions apply in respect of business done in whole or in part within the European Union. And this is probably the most vague criterion among these 5 criteria that we've outlined. It's still unclear how far the European Commission will go in interpreting this criterion. But basically, if you have a transaction that touches the EU territory, then the sanctions legislation applies. And it could be that the EU will say that if part of your turnover is realized on EU territory, that's sufficient to bring you under the scope of the EU sanctions. And then finally, of course, because there is this territorial link, it also applies aboard any aircraft or vessel under EU member state jurisdiction. So a few things to underscore is that EU nationals and EU companies must comply with the sanctions wherever they are, meaning also abroad. Second, foreign companies must comply with the sanctions with respect to any of their activities that have a clear link with the EU territory. That might be the case, for example, because you're using an EU bank for the payment in respect of a particular transaction. And third, persons and entities outside EU jurisdiction, so for example, Brazilian companies, also need to be careful that they're not implicated in any type of circumvention of the sanctions. So let's assume we have a Brazilian parent company with an EU subsidiary, but also a subsidiary in another jurisdiction that doesn't apply any sanctions. Then the EU subsidiary that can't make a payment anymore to Russia can't use the other subsidiary to circumvent the EU sanctions. So it's very important for Brazilian companies that have subsidiaries in the European Union that they need to be careful in terms of the instructions they give in respect of transactions that have a Russian link. It's also important for Brazilian companies to check their entire supply chain and whether or not it touches EU territory. For example, because of means of transport, for example, because of where the products pass in transit or from where they are exported. Also, you want to check if you're using any EU bank for your transactions with Russian clients, because that means that the sanctions legislation applies. And as I already underscored, it's important to avoid any risk of participating in an attempt to circumvent the EU sanctions. Next slide, please. So let's start now with looking at these three different groups of sanctions. And as I outlined, the first group are the so-called targeted sanctions. So here we have now a growing list of persons and entities that are included in the EU sanctions list, which is also publicly available, similar to what's the case in the US. In essence, so you want to check your transactions to see if any person or entity involved in that transaction appears in that list. If they do, there are three consequences that follow. The first is that the funds or economic resources of these persons, so not just bank accounts, also their ships, their boats, their houses, etc., these assets need to be frozen. Now, this has become a bit more complicated because in the list, there are now also a lot of Russian banks. And of course, the EU does not have jurisdiction to freeze accounts held in a Russian bank. But what happens is that if an EU bank receives a payment from a Russian bank that appears on this list, they will simply not accept the payment or freeze the payment. Second, for listed persons, there is a travel ban. And then third, and this is maybe the most important consequence, there is a prohibition to make funds and economic resources available to any of these persons or entities. And making an economic resource available means, in essence, doing anything for that person that results in an economic value for that person. So that's kind of the initial screening you want to do. However, it's not sufficient to conclude that the person or the entity with which you're in a transaction is not listed. You also need to look who is behind the entity. So even if it's a non-listed entity, but it is owned or controlled by a listed person or entity, these sanctions, these targeted sanctions apply. For ownership, there is a 50% threshold that applies. And then for control, we look at whether or not the listed person or entity has a decisive influence on the non-listed entity. And there are different criteria that can be used to make that assessment. Although there is no triggering of the sanctions in respect to associated persons, as our American colleagues also explained, what a lot of the listed persons did shortly before or after being listed is that they gave some of their shares in companies to, for example, a family member. And here, increasingly, the European Commission says that this results in a very high compliance risks. So that's something else to screen in your transactions. Now, although we won't go into the details of the various derogations and carve-outs or winding down periods that apply, just want to outline that for the different sanctions, there can be different types of derogations. A derogation means that in principle, the sanction applies, but you can ask for a license, what we call under EU law an authorization, to nonetheless, for example, complete a transaction. But you must obtain a license or authorization. And to ask for that, you don't go to the European Commission in Brussels. You have to go to the member state that is competent to deal with your transaction. There can be certain carve-outs in the sanctions. So those are actually types of conduct that simply don't fall within the scope of the sanction. That's allowed, and you don't need a license for that purpose. But so, for example, interest payments can still be made within the frozen accounts. However, the payment itself, the interest, becomes then also frozen. And as we'll see in respect of some of the other sanctions, there are also sometimes winding down periods. So sometimes the EU allows you to still complete certain transactions that started before the person was listed or before the sanctions applies. But I do want to stress that there is no general transitional period. So there is no, for example, grace period of, let's say, a month or 2 months, giving anyone who falls under the scope of the sanctions time to bring itself into compliance. The sanctions apply from the moment that the EU regulations are adopted and published. Next slide, please. Now, apart from checking this list of persons and entities, because of the Russia sanctions, you also need to check if your transaction has any connection with a listed Russian state-owned enterprises, which I have listed on this slide. If your transaction has any link with these companies, you need to be particularly careful and apply extra due diligence and check whether or not the transaction can be carried out under the EU sanctions. Because in essence, if it's a transaction with any of these companies, then it means that no transaction can be carried out, subject again to certain carve-outs and winding down periods. Next slide, please. So the second group of sanctions, as we explained, are the so-called trade sanctions. And broadly speaking, they consist of export restrictions, import restrictions, and transport restrictions. So first, in respect of the export restrictions, the first thing to stress is that it's not just a restriction of exports or a prohibition of exports, more precisely. It's also a prohibition on the sale, supply, or transfer of products to Russia or for use in Russia. And this is irrespective of the origin of the exported products. So even if an EU company, for example, that sells to Russia certain goods that originate from Brazil, and those goods appear on the list of products that can't be exported or sold to Russia, the sanctions legislation will prevent this EU company from making that particular transaction. So that's also an indirect manner in which Brazilian companies can be affected by these EU sanctions. And then we have various lists of products that can be exported. They are nicely kind of organized according to certain categories, such as advanced goods, software, dual-use software and technology can't be exported regardless of whether it's civil or military use. But there's now also this wider list that talks about key industrial inputs. So that covers many different types of products, such as chemicals, wood fabrics, building materials, glass, steel, machinery, etc. Next slide, please. Apart from these three lists of products, we also have lists relating to maritime navigation goods, all exploration goods, luxury products, oil and gas production goods, and now also aerospace goods and jet fuel. And these lists are simply becoming longer, and new lists are added with each sanctions package of the European Union. Next slide, please. Now, one point to stress in respect of both the export and import restrictions, and I should have made this point also when talking about the export restrictions specifically, is that it's not only prohibited to export the goods, but also to provide any related services. So if you're providing any maintenance services with respect of these products in Russia, that's also covered by the sanctions. The same applies to the import restrictions. And here again, I underscore that the import restrictions don't simply prohibit imports, but also the purchase and transport of certain products originating or exported from Russia into the EU. Now, initially, the European Union started with applying a lot of export restrictions, but now gradually the European Union is widening also the scope of the import restrictions or import prohibitions. So now we have 3 lists of products. The first list deals with various types of steel products. The second covers key industrial outputs, and here we stress that it, for example, covers fertilizers imported from Russia. And then third, it covers also coal and solid fossil fuels. So you'll note, of course, that oil and natural gas are not yet included in these lists, but it's most likely that in the 6th sanctions package of the EU, those will be included. Next slide, please. In respect of the transport restrictions, in essence, there are significant prohibitions that apply in respect of transport by air, maritime transport, and by road. It seems that currently the EU is not yet covering in its sanctions also transport by rail. There are particular type of carve-outs, derogations available, but in essence, this further, of course, complicates any trade between the EU and Russia, and might also indirectly affect supply chains that cover Brazil. Next slide, please. So just a few kind of points to underscore in respect of export restrictions and transit, transport bans. These are just some frequently asked questions that have been clarified by the Commission. But in the interest of time, I suggest we move on to the next slide. Similar to what's the case for the US sanctions, there are certain sanctions that apply for imports and exports to Donetsk and the Lugansk regions. There's also a suspension of broadcasting activities in the EU of Sputnik and Russia Today. This is very far-reaching for the EU to impose such a restriction basically on the freedom of expression. And then there's also suspension of facilitated access to EU short-stay visas. Next slide, please. So what does this all mean then for Brazilian companies? It means that your supply chain, as I already explained, might be infected by these import, export, and transport restrictions. So for any of your operations that somehow touch on the EU trade, on the EU territory, the trade sanctions might prohibit onward trade with Russia. For example, because you're using a warehouse in Europe, you're sourcing inputs from Russia through EU ports. And we want to stress that even if a Brazilian company might not be bound by the sanctions legislation, its EU-based subsidiaries and any intermediaries will be covered by these sanctions and therefore might refuse to engage in any trade with Russia. So it's important as part of your due diligence that you check what are the links with the EU territory in your supply chain, and also that you check the classification of any goods and services that you provide and that have move across to or come from EU or Russia, to check whether these goods especially are covered in any of the lists that the EU has published and to which the import and export prohibitions apply. And eventually you might need to look for alternative routes for any trade you're still carrying out with Russian entities, Russian partners. But here again, I stress the importance of avoiding that you're involved in any type of circumvention action with an EU company. I'll now turn to my colleague Aldo, who will tell you more about the financial sanctions and also will explain in greater detail the type of due diligence assessment that you can make as a Brazilian company. Thank you.
Thank you, Isabelle. Thank you very much for this clear and comprehensive overview of the sanctions. Now we will briefly talk about financial sanctions. It's the third type of sanctions we mentioned in our presentation, in addition to targeted sanctions and trade sanctions. It's a very wide group of sanctions, including several restrictions concerning all the financial operations with Russian entities. First of all, the SWIFT ban. The SWIFT ban is a very peculiar measure, unprecedented. It's the first time the European Union adopts this kind of measure, and it consists of an exclusion from SWIFT financial messaging system of 7 Russian banks. They are the major Russian banks. As you can see, Sberbank is not there. There is a big discussion within the Union as to the inclusion of this bank, and which will be hopefully included in the next package. It's interesting to note that concerning the SWIFT ban, this prohibition applies to all the entities, so all the banks, irrespective of their location. So even to banks established under the law of a third country, so non-EU banks, in cases where the transaction involves one of the 7 Russian banks listed in this slide. This may generate some confusion because it looks like, this kind of measure has extraterritorial effect, is not an extraterritorial reach of the EU sanctions, but the simple reason why this measure can be applied also towards other subjects is that SWIFT is a Belgian company. So as such, that company providing that service is bound by EU sanctions. Then we have corporate finance restrictions on dealings in corporate debt and securities, including crypto assets. So it is not possible to purchase or sell or supply services related to transferable securities or money market instruments issued by major Russian banks and defense companies. Importantly, from 12 April 2022, this restriction has been extended to financial instruments issued by state-owned oil companies in Russia and credit institutions supporting the Russian government, as well as other financial institutions economically benefiting from their connection with the Russian government. Then sovereign debt, there's a restriction involving the Russian government central bank of Russia. So it is prohibited to extend credit and loans to and purchase, sell and trade transferable security and bonds issued by those entities, national and state-owned entities, of course. In addition to these three restrictions, there are also restrictions concerning the financial services. So restrictions on the supply of certain specific financial services. First of all, the acceptance of deposits of holding crypto assets from Russian entities, national and residents in Russia. It is prohibited to accept deposits over euro 100,000 and to provide custody services for crypto assets valued over 10,000 euros. So it's a small value, as you can see. In addition to that, credit rating services and central security depositories. Also in this respect, it is prohibited for EU central security depositories to provide financial services, as well as to supply credit rating services to Russian entities. Other restrictions cover services relating to trusts, the banknote export. It is prohibited to use euros, basically, this and other currencies of EU member states. And finally, procurement. So there is also an exclusion for all the EU operators from EU public procurement concerning Russian entities. In particular, it is prohibited to award or continue to execute public concessions contract within the scope of the EU procurement directives when Russian nationals, entities, or entities owned by Russian national or entity are involved. There are some derogations applicable, as Isabelle already explained, for instance, these are applicable to contracts in civil and nuclear sector, space cooperation, etc. Public finance, finally, there is an exclusion from EU and member state financing and financial assistance concerning the EU member state and Euratom finance programs. So it is prohibited for Russian entities to access funds, EU funds, or financing from those bodies, for instance, in the framework of Horizon 2020 and other EU programs. And the public trade and investment support from the very beginning of the adoption of the sanction, 26th of February, it is prohibited to provide financing for trade with or investment in Russia. Also in this case, a carve-out is applicable. But we briefly described these instruments, but what is the impact on Brazilian companies? First of all, it is important to note that EU banks are bound by EU sanctions legislation. So even if a Brazilian company is not bound as such by EU sanctions law, because there is no extraterritoriality, as we know, as we discussed, all payments to or from Russian persons and entities involving EU banks might prove to be difficult. So if a Brazilian company engages in a transaction with a Russian company and the payment is made through an EU bank, that transaction may be caused by EU sanctions. Even if a Russian counterpart is not subject to EU sanctions, banks might adopt a zero-risk approach. This is something we observed recently for some of our clients, and we noted that EU banks are taking this zero-risk approach, and they prefer not to carry out a transaction, to stop a transaction if there is a possible risk of violation or circumvention of the EU, not only EU sanctions, but also UK and US sanctions, for instance. So it's very important to double check if EU banks are involved and perhaps discuss with the banks involved if a transaction may give rise to sanctions-related risks. So some precautions has to be taken. For instance, EU banks used in the transaction, it should be checked, as I just said, and the operators should also identify alternative payment channels unaffected by the sanctions currently in force. Now, let's turn to the maybe one of the most interesting points we will address today, which is the compliance, the due diligence to be carried out in case of transactions involving Russian entities and I would say also EU entities. So first of all, let's start from the starting point is that the exporter, the Brazilian exporter, for instance, is not liable when violating EU sanctions. if it didn't know and had no reasonable cause to suspect that the actions carried out would infringe the measures. As we explained, as Isabelle explained, Brazilian exporters are not as such bound by EU sanctions, but it is important to, carry out due diligence. So first of all, the Commission even issued some guidance concerning the due diligence the Commission expects all the operators to do. So there are 4 steps to be done. The first one is the risk screening, then the risk assessment, the compliance checks, and the continued monitoring. Let's address now the first step, which is the risk screening. So first of all, the operator, the exporter, should gather standard information from its customers using, for instance, questionnaires. We understand it's not easy to send questionnaires, especially when there is a long-standing relationship with the customers, but this is very important. And we should gather information concerning the product or service at issue, including the end use of the product, for instance, the parties involved in the transaction, the destination of the goods, and the payment channels. So the exporter should determine relevant risks or touch points with Russia and EU, as said. So the questions to be asked are there listed persons involved in the transactions? First of all, there are tools to check. Of course, there is a consolidated list, but also consultants, they have special tools to double check whether there is any listed entity or person involved in the transaction. Then, sanctioned banks. Is there any bank listed involved in the transaction? And here I would add also EU banks, because this can be a link with the EU. So if a transaction involves any EU operator, the whole transaction may be affected by the application of EU sanctions. What is the country of destination? If it is a targeted country, for instance, is there any possibility to circumvent the sanctions? And also the means of transportation, which would be affected by the sanctions. So once this first step, with this step of risk screening is carried out, we invite all the operator to assess the risks. Then, I mean, based on the information gathered from the customers and through other tools, so in the risk screening phase, it should be identified if there is any red flag risk. And so it's important to assign, according to this, division we suggested in this slide, if there is a low risk, medium risk, and high risk concerning the transaction at stake. So if there is a low risk, of course, the transaction can be performed, can be done. The only thing is to continue, the monitoring also for the future. If there is a medium or high risk, a compliance check should be done. So in practice, it should be checked carefully if there is a specific sanction applying to that transaction, and if there is a concrete risk that the transaction can be blocked. Sanction enforcement. Isabelle already mentioned that in our system under EU law, sanctions are adopted by the Council of the European Union, but an important, significant role is also played by the authorities of the member states. So there is, the member states have the responsibility for the enforcement and implementation of the sanctions at a national level. They, are responsible for determining the penalties to be applied, for instance, in the event of infringements of the sanctions, if the relevant operator intends to request derogation, or to, there is a doubt about the application of a carve-out, for instance, it should not go to Brussels, to the Commission, but it should ask the relevant national authority to authorize that transaction, to issue a license, for instance. So it's a quite complex system involving all the authorities in all the 27 member states of the European Union. And member states also gather information about the implementation of the sanctions and coordinate with the Commission. The European Commission has a role of a supervisor, basically. So it is responsible for the uniform application of the sanctions within the territory of the Union, of the European Union, issues opinions to the competent authorities in the member states, normally upon request of the authorities. Sometimes there is a doubt concerning the application of or the interpretation of a certain criteria. We saw, for instance, the criteria concerning the business done wholly or partly within the Union, which is something, which has not been interpreted by the Commission or the EU courts so far. So it's really hard to understand what does it mean. So it's important also to have guidance on the part of the Commission. Lastly, we prepare, I think there is still time to cover this case study we prepared, just to give you an example of application of EU sanctions with regard to, for instance, a Brazilian purchaser of fertilizers from Russia. Here we have a case where a Brazilian company purchases Russian fertilizers through a contract concluded with a seller, a trading company established in Switzerland, and the payment is made through a bank in the EU. So we have for sure a link with you in this case, which is the bank. Otherwise, there will be no link, in the sense that the contract is concluded with a Swiss company. So in that case, Swiss sanctions may apply, but certainly not EU sanctions. And the transaction concerns a product, fertilizers, which is covered by the EU sanctions. We have an import ban on Russian fertilizers in place in the Union, and also, depending on the CN codes on the specific type of fertilizers, also a quota. There is a maximum volume of fertilizers that can be imported freely in the Union without the application of the relevant sanctions against Russia. In this case, what is the conclusion? First of all, the payment to an EU bank account means that the purchaser is conducting business partly within the Union. There is no doubt about that. So the operation, the transaction involves the EU, is done from the territory, at least partly from the territory of the Union, so EU sanctions apply. So two consequences. The first one, the purchaser must comply with EU sanctions in respect of the payment. So the bank, for instance, must conduct a screening about the parties involved. The funds, as Isabelle explained, may be frozen, for instance, if there is a listed Russian bank involved in the transaction. The second consequence is that the purchaser may be bound by other EU sanctions, for instance, the ban on imports of fertilizers from Russia, because the transaction is made partly in the territory of the Union. So as you can see, in this specific case, the mere presence of an EU bank involved in the transaction can trigger the application of the EU sanctions also with regard to Brazilian company. So lastly, we prepared a slide with a list of resources where you can find useful information concerning the application of the EU restrictive measures or sanctions in general, and in particular against Russia. We issued as a firm a guide to EU sanctions against Russia, and we just put the link in this slide. Thank you very much. Isabelle, I don't know if you have time, if you wish to conclude or to add something.
Oh, I think it's time for Q&A now. Thank you.
Yes, thank you. It was a very interesting presentation, all of them. Now we have some questions posed by the audience, but I would like your permission to use my prerogative as a co-moderator to ask the first one. I read on the news about a speech given last week by Janet Yellen, the U.S. Treasury Secretary, at the Atlantic Council about the sanctions against Russia. And now I will quote her. She said, "Let me now say a few words to those countries who are currently sitting on the fence, perhaps seeing an opportunity to gain by preserving their relationship with Russia and backfilling the void left by others. Such motivations are short-sighted." And then she continued, and I'm quoting again. "Let's be clear. The unified coalition of sanctioning countries will not be indifferent to actions that undermine the sanctions we've put in place." So I would like to ask my US colleagues, what does this quite harsh speech given by Janet Yellen means? And what exactly could be the consequences for the countries like Brazil that are currently sitting on the fence on the economic sanctions aspects of the Russian-Ukraine conflict?
Thank you, Mauro. I saw Ms. Yellen's speech. I think we've heard echoes of the same sentiment from other members of the U.S. administration. I read it immediately, and hopefully you'll take this the right way. I did not think of Brazil when she said that. I think everybody thought of one country, and I think it's China. So the potential, there is a real potential for the sanctions to be less effective if the Chinese trade with and provide other forms of financial support to the Russians. I don't know exactly what form that would take. The way she was speaking, but it could be the type of thing that could generate a secondary sanction. Remember how I talked about earlier? I said secondary sanctions are rarely used, but if a person not subject to U.S. jurisdiction engages in some activities that are particularly troublesome, they could be targeted. And in fact, that type of extraterritorial and sometimes controversial authority is much more likely to be used against the Chinese party than it is against a European party, and I would suggest even less so than against a Brazilian party. I mean, the closer you are allied with the United States, the less likely that's to be used. So I think that was a warning to China, and I don't think, and I'll say one other thing, and I don't think it just means routine trading or routine business activity that does not implicate U.S. or European or UK sanctions because it's not subject to jurisdiction. I think it probably means more wide scale, more significant. There's a certain scale that it would have to be at, I think, to trigger a response. I'll pause there. I don't know whether Isabelle has anything to add on that.
Well, maybe just three brief points. I fully agree that that's in these voices or this kind of speech we're hearing this also in Europe, in Brussels. It was, of course, mostly targeting China. I don't think the EU is currently contemplating adopting sanctions against countries because they have not adopted sanctions against Russia, or they are kind of supporting Russia. But there can sometimes be trigger points. Of course, the involvement of Belarus in the conflict has already caused sanctions also to apply. But I think that the EU first wants to focus on imposing many more sanctions directly on Russia before it would go, take such a step. I do think that it means when the same type of speech is heard in the European Union, that we'll see an unprecedented enforcement of sanctions, and also in respect of this risk of circumvention that we explained in our presentation. So even if Brazilian companies are implicated, if they find the jurisdictional basis to apply the sanctions, they will do it. So that might be something new and something that companies in other countries have not previously seen that the Commission and especially the member states will go as far in their enforcement of the sanctions. And the third point is that the fact that the world now does seem to be divided, at least in three groups, the active supporters of Russia and its active supporters, the countries adopting sanctions and the countries not adopting sanctions, but also not supporting Russia, it weakens cooperation in so many different fora, affecting trade, affecting all different areas. So it's not just a question of looking at these comments through the prism of does a sanction apply or not. We're seeing that cooperation in many different international fora, aimed also at facilitating, for example, trade, are significantly being hampered because the world now is at least divided, it seems, in these three different groups of countries. Thank you.
Well, one other thing I'll add, Mauro, in response to that question is sometimes statements like that they could be a preview of a potential policy response, but they're also, to caution. I think those kinds of statements also make, they make third countries think twice. They may, and we've already seen examples. A lot of people thought that, the Chinese would rush in and would provide support and would engage in transactions. I mean, we've already seen some examples of Chinese banks hesitating to do some things. I mean, I think other countries are hesitant to put themselves too deeply into the crossfire there. So some of that I think is just sort of intended to persuade people to be very cautious about being on the wrong side of that choice. As Isabelle said, there's those who are opposing sanctions and those who are supporting Russia. You don't want to be in the supporting Russia category. You can kind of be more neutral, and probably just be cautious about the types of transactions you're doing. It's a very good question, something to watch.
Thank you, Jason and Isabelle. We have another question from Mr. Marcel Ribas from the audience. He asked whether a US person can be penalized, and I think this could be extended to the EU as well. So can a US or a EU person be penalized if a non-US company where the US person owns a controlling stake? So I think that would be like a Brazilian company where a EU or a US person has a non-controlling stake, does business with Russian SDNs or in US sanctioned sectors. Jason, Lucas, I think you could go first on this one.
Let me try to give a clear answer on this. So the Russia sanctions, the jurisdictional scope of those sanctions, the parties who are covered by those sanctions and restrictions are US corporations, US citizens, US residents, people in the United States. Okay, the US sanction, these sanctions do not apply where the US person owns a non-controlling stake. I'm assuming this is a non-controlling stake in a non-US company. I mean, I think if the company is organized under the laws of Luxembourg, it's not subject to the US sanctions. The US person who happens to own some shares in that company is not, if that company engages in activities, provided that US person isn't involved in those activities and has nothing to do with those activities. They didn't approve them, they didn't facilitate them, they didn't advise on them, or so if it's a passive shareholder and the entity involved is not a US person, then I don't believe that the passive shareholder can be held individually liable for the actions of a non-US corporation. But again, that person can't be involved. They can't be involved in the violative activity.
Thank you. We are very short on time, but I can see that Claudia wants to pose a question. So Claudia.
Thanks, Mauro. Thanks. I think from both presentations, which were very good, it seems that financial institutions usually are very cautious on the transactions or the type of transactions. And I think this is something that is of interest, might be of interest for Brazilian companies, because usually banks may base their decisions on best practices, which increases the bar in allowing a certain transaction to move forward without no specific regulation on that. I understand there is compliance issues involved for financial, especially big financial institutions, but I'd like you guys to comment a little bit on that and how to try and avoid or try and have the financial institutions more involved or taking a little more risk, especially when there is no specific sanction to a person or an entity involved in the transaction. Thanks.
Do you want to go, Aldo? Do you want to say a couple words? You mentioned that, and I can chime in as well.
You can go first, please.
So you're absolutely right, Claudia. The banks are they're de-risking, as we've all said. They want to avoid risk. They're also they're looking at multiple lists. We've got an EU list. We've got US list, we've got a UK list, we've got multiple lists. And oftentimes banks will have, even a bank in Brazil, they may have a system that's screening against all those lists. As a practical matter, you can imagine it from the bank's perspective. They've got a wire coming in or a wire going out. They're not, in routine types of commercial transactions, they're not making a ton of money. And for them to be processing that wire, if there's risk, they don't want to do it. So here's what I would suggest. I mean, where we have that concern, and we do this, we've done this with banks. If we know a transaction is likely to throw a risk flag within a bank, the best thing to do is to go to the bank in advance. I would tell, do you have a relationship with your bank? We can't go telling them every time we think that there's some slight possibility of but if we know this is a transaction, especially if it's a meaningful size transaction, we would go to the bank and we would try to explain it to their compliance people. This is coming. Here's what it is. Here's a good example of that is where there's a license. Hey, this you might think this is prohibited, but here's a license that we're using. We want you to be aware of this. Or you might be concerned that this company is sanctioned, but here's our research and here's the file we've put together on their ownership. Try to get ahead of it. That is not always very easy, and it's kind of difficult to do for every single routine payment transaction. But certainly on any transaction of import, I think it's something worth doing. And it is a good, so I would start with your relationship banker and then try to get connected to the compliance people, and in some of the bigger banks, we've done this before, so we have relationships with their compliance people, and it's better to get in front of that. Oftentimes the bank likes to have something in their file. Oh, we got a letter from a law firm, or we got a due diligence report from the bank client. This is in our file, and we're going to sign off.
Yes, I totally agree. I mean, it's the same in the EU. We just observed that some of the banks are taking this zero risk approach because they don't want. It's also, a kind of reputational concern they have if they, may be seen as involved in the transaction involving listed persons, for instance. But yes, the right approach would be talk to your bank and try to control this kind of risks if you have a good relationship, and normally operators have a good relationship with the bank, because banks are now screening, and not only as concerns in the EU scenario, not only based on EU sanctions, but also they are concerned about the application of US sanctions, for instance, because there is extraterritoriality there. We have Swiss sanctions, and we have a lot of companies established in Switzerland trading goods within the union, basically. They are used only, for paperwork, and they issue invoices, we all know, and the same applies to UK sanctions. So it's important to really to talk to your bank if there is a transaction involving sanctioned persons or entities, and which is made through payments with EU banks in our case. So I totally agree with the approach from the US colleagues. Isabelle, would you
Yeah, maybe 2 points to add. What you're seeing, first of all, you're seeing a lot of Russian companies now, as it was already mentioned, making statements on their websites, or they are issuing letters saying everything is fine with us. That's of course not sufficient to take to your bank, because you need to ask then for all the underlying documentation, possible articles of association, trust deeds, etc. So it's not sufficient to just take the document that you might be receiving from your Russian partner. A second point in respect of the banks is that what we have noticed is that some banks have now been buying claims of Russian companies for payment. And the Commission European Union has not yet taken a position on. So the idea is, before, a lot of banks now are buying the payment claims from Russian companies, even if they're not listed, but anticipating the future sanctions that might apply. And that's something, it might be possible to, in that situation, make the payment to this bank that bought the claim rather than to your Russian partner. But it's something you have to screen carefully and check ask for legal advice before making then that payment to that bank that bought the claims. But this is something that a type of solution that you might be hearing increasingly in order to still make payments to Russia. Thank you.
Great. Well, unfortunately, we have run out of time. I can see that there are still some questions which were not answered. And for that, I would ask for Dora's and IBRAC's staff to liaise with the speakers in order for the audience to get the answers to the questions, if possible. So, as I said, it was a very hot topic and lots of things to be discussed, but we have to find an end to it. So I would like to ask the speakers, IBRAC's organization, and of course the audience that participate very actively on this webinar. And we hope to see you soon in other IBRAC's events. Thank you.